I would like to share with the class and whoever may be watching some good news, because I have some, unfortunately, very bad news to share with you. So the good news is Venezuela almost certainly is going to survive. Short of Trump declaring war in fact or in action, the American attempt at a coup d'etat in Venezuela has fallen flatter than last week's pancakes. Iran is going to survive, and even fortunately, through the help of Russia and China, a number of other countries are slowly but surely extricating themselves from the SWIFT financial system, which is going to let a multipolar world develop in spite of American attempts at destroying it. The bad news in an immediate sense is that South America is now thoroughly under the heel of the United States government. Ecuador is almost certainly going to surrender Julian Assange in the next day or two or three. There was somebody mentioned a quote that a diplomat uttered shortly before the onset of World War I. The diplomat said, "The lights are going out all over Europe. They will not come back on again in our lifetime." And I am very grieved to observe that that kind of statement is probably appropriate now in terms of Western intellectual and moral development. When Julian Assange is arrested, the assault on the media will be nearly complete. For the last 19 years, 18 years, we have been getting progressive propaganda rather than information from all of the sources of news in the West, probably dating back to when Bill Clinton allowed multiple news medias to come together in larger and larger corporations, so that now the news that every American gets is controlled by 6 corporate managers. And those corporate managers have progressively been feeding the American people nonsense or excrement, depending on how you choose to express yourself. InformationClearinghouse.info, one of my half dozen or dozen good internet sources, is being denied service by their ISP. They're rapidly developing alternative methods of service, but it's reflective of the way Google and Facebook and Twitter are being manipulated. So if you don't have an internet source of information, or several internet sources of information, I would strongly advise you to get them, because whatever you hear on the media, whether we're talking about National Public Radio or Fox or any of the stations in between, is being dictated to their managers from on high. Whether on high is the Trump party or the Deep State party or the Zionist party, they are fighting about certain side issues. But the major issue is that they still want the United States to be the hegemon of the world. That's not going to succeed, but the United States and its vassal states can create a great deal of trouble in the process of resisting that program. Russia is not going to fall. It's the only nation state in the world that can effectively defend itself and destroy the United States. No nation state in the world today can protect itself against a nuclear attack. But there are several nation states that can successfully retaliate if they are attacked. The United States leadership in the last 10 years has convinced itself that they can start a nuclear war, survive a retaliatory attack, and give a second wave of nuclear weapons, and, quote, succeed. As one of these not so brilliant analysts said, if 2 Americans survive and 1 Russian survive, we've won. That definition of victory probably tells you a great deal about the level of moral thinking and indeed rational thinking that is present in American leadership. But the people behind the United States have been behind the United States since at least 1864, and they like the power that the United States can wield in the world, and they are going to be very reluctant to give it up. There is, I found out in the last few days, evidence that Japan was forced to give control of their financial system over to a number of American and European oligarchs, and as evidence that they needed to yield, that they needed to surrender the financial system, there is at least some evidence that the earthquake and tsunami that created the Fukushima disaster, it is conceivable that that was generated by an underwater nuclear weapon, and it's conceivable that it was basically being used as blackmail. So when you're talking about power groups that are willing to contaminate the world with nuclear waste, and who clearly have said that they want the human population reduced to several million, because they don't need more than several million servants, you're talking about a different kind of humanity than we have experienced in the last several millennia. So the bad news is that the people who are making decisions now are not thinking in exactly the same way that you and I are thinking. Venezuela is going to survive, and I want to point out to our students and anyone watching, in large measure, Venezuela is going to survive because the Venezuelans are supporting one another. In addition to supporting Maduro as the president of Venezuela, they are feeding themselves. They are growing food inside the cities. They have support groups in the barrios and in the countryside that, as communes, terrible word, isn't it? As organizations cooperating person to person, they're growing growing food and feeding one another. Russia, fortunately, is supplying with certain essential medical items, and both Russia and China are giving messages saying that the Monroe Doctrine is dead on its heels, fortunately. It seems very likely that people will pound their chests in the immediate future, but nothing further is going to happen. I mentioned the date 1864 a few moments ago. 1864 is the year when the Rump Congress of the United States, and I call it Rump because the southern states were no longer represented, so you did not have a legitimate Congress of the United States. But the Rump Congress passed a law saying that the word state, henceforth in any congressional legislation, would have a specific statutory meaning. 99 times out of 100, people would hear that and they would yawn, and quite rightly so. But the reason the date is important and the reason the definition, the specific legal definition of state is important, is because a few years later, Congress also passed a law creating a government for the District of Columbia. That government for the District of Columbia is in some cases called the Municipality of the District of Columbia. In other places it is called the United States, so that you have the United States, that is the entity created by the union of multiple sovereign states, but you also have a political entity called the United States, whose territory is the District of Columbia and the possessions and territories of those same United States. By creating a statutory definition of state, what it means to be a citizen of the United States has acquired a second meaning. Up until 1864, a citizen of the United States wasn't defined, but the phrase was used. The phrase was used on multiple occasions in the Constitution, defining the qualifications for a United States President, a United States Senator, and a United States Representative. In each of those cases, the individual had to be a citizen of the United States and had to be a resident of the United States for X number of years, X being dependent on the several offices I mentioned. But it never defined citizen of the United States. A judge by the name of De La Guerra very wisely issued an opinion that delineated very carefully and accurately what the writers of the Constitution clearly intended. Since George Washington could not possibly have been a citizen of the United States for 7 years, when the United States had not been in existence 7 years, the writers of the Constitution meant something different. And De La Guerra, in the opinion of everyone who's read him, to my knowledge, was right. What the writers intended was to say that the president needed to be a citizen of one of the several states of the United States and have been a citizen of that state for X number of years, and as derivative of being a citizen of one of the states, the president was also a citizen of the United States. And when you're reading this, you can tell the special meaning of the word citizen because it is capitalized. Before 1864, in the Constitution and in federal legislation, if the federal legislation mentioned citizen, it was capitalized. It was part of a proper noun. Citizen of the United States was a proper noun. With the passage of the 14th Amendment, citizen turned into a common noun, so that when it is written as a common noun, it's produced in a small c. Everywhere you see in the 1040 manuals, when you see in a description of a passport application, anyway, when you see it in the form that you fill out for giving yourself or being given the privilege of voting in Iowa, U.S. citizen, the C is a small c. It is a common noun rather than a proper noun. So you have derivative citizenship in the United States prior to 1864. After 1864, the only citizenship that is written about is citizenship in the corporation known as the United States, whose municipality is the District of Columbia. I'm not just talking about dusty facts, because as a citizen of the state of Iowa, with a capital C, I enjoy all of the rights and protections and immunities excuse me on that, granted me by the Bill of Rights. As a citizen of the United States, small c, I have the rights that Congress deigns to give me, which are limited in the first, as far as the Bill of Rights is concerned, Congress consents to give me limited aspects of the first 8 articles of the Bill of Rights, and none of the aspects of Article 9 and 10 of the Bill of Rights. And what Congress gives you, guess what? Congress can take away. So there is a vast difference between being a citizen of the United States as a proper noun and a citizen of the United States as being a common noun. The film I'm going to show you is an exposition of some of the aspects of reading the Constitution and understanding the differences between those two types of citizenship. I wanted to point out that the corruption that has taken place in American government did not start with the Second World War, did not start in 1933 or 1912, the dates of the election of Franklin Delano Roosevelt, or the emergence of the Federal Reserve Bank, started all the way back in 1864, and it was planned for because of a corporation that was adopted as the government of the District of Columbia, that was incorporated into the act of establishment of the DC government in 1871. People in government during the Civil War were trying to figure out how they could get around the apportionment clause of the Constitution. They haven't. What they have done is convince every one of you and myself to volunteer to being small c citizens of the United States. And in convincing us to do so, we are obliged to obey every single statute of the United States as it pertains to its citizens. And because the states have accepted certain privileges, you also have to obey all the state statutes, so that your state child welfare system claims the privilege of controlling your child. So I'm going to stop there and show you a little video. Actually, it takes about 30 minutes, but it's an excellent introduction by an ex-convict who studied and educated himself with respect to the law. And he does a very good job of excellent job of educating himself, and I think he'll do an excellent job of getting started on your education. Let me get it started.
The Buck Act and the United States of America. This is a map of the United States of America. It includes the 50 sovereign and independent states who are freely associated together in a union. It does not include the District of Columbia, which was created by the Constitution of the Union as the legal home of the federal government. That government was intended to be a servant to the Union states, not their master. In order for the federal government to tax a citizen of one of the several states, they had to create a contractual nexus. This contractual nexus is called Social Security. The federal government always does everything according to principles of law. In 1935, the federal government instituted Social Security. The Social Security Board then created 10 Social Security districts, creating a federal area which covered the several states like an overlay. In 1939, the federal government instituted the Public Salary Tax Act of 1939, which is a municipal law of the District of Columbia taxing all federal and state government employees and those who live and work in any federal area. Now the government knows it cannot tax those citizens who live and work outside the territorial jurisdiction of Article 1, Section 8, Clause 17, or Article 4, Section 3, Clause 2. So, in 1940, Congress passed the Buck Act, Title 4, United States Code Services, Sections 104 through 113. In Section 110E, this act allowed any department of the federal government to create a federal area for imposition of the Federal Salary Tax Act of 1939. The imposition of this tax is at Title 4, United States Code Services, Section 111, and the rest of the taxing law is in Title 26, the Internal Revenue Code. The Social Security Board had already created an overlay of a federal area. As a result, the federal government created federal states, which are exactly like the sovereign states and occupy the same territory and boundaries, but whose names are capitalized versions of the sovereign states.
I'm going to stop for just a second. A state in this situation is not a geographical area. It's a body politic. If all the redheads of Iowa wanted to become this kind of corporate state, they could incorporate themselves as the redheaded people of Iowa. That would be an overlay on Iowa as a geographical area, but it would be a separate state. There are at least two functioning legal entities called the state of Iowa besides the actual geographical state of Iowa. Both of those legal entities are subservient to the government of the United States, that is the government of the District of Columbia. When I finally got my head around this idea of a legal fiction, a legal creation, sitting on top of the real geographical state, I started to understand a great deal more.
Okay, I want to pause right here, and we need to get some clarification on this word state, because as it was said in this document, the federal government does everything by principles, law principles. You need to study principles because everything is based off a principle of law. Something like how silence is acquiescence and, ignorance of the law is no excuse, things of that nature. You have to learn the principles because they base everything off the principles. They know the principles. And state is a word that when I first got into this, I was stressed to understand the word state and the word citizen. It's one of amongst the first words that I looked up. And I'm going to give you an example of what I'm talking about. I'm in a Black's Law 4th edition, and you can see state, which is a noun. And, here's the general definition. A people permanently occupying a fixed territory bound together by common law, habits and customs into one body politic, exercising through the medium of an organized government, independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace and of entering into international relations with other communities of the globe. And that is like an over definition, what applies to all situations, general definition, which is what usually the first sense of the word is. Then you get to more narrow senses of it as you go on into the other senses. And let's look at the second one. It says, one of the component commonwealths of states of the United States of America. The term is sometimes applied also to governmental agencies authorized by state, such as municipal corporations. So sometimes this term state is a municipal corporation is called a state, like U.S. Corp, or like state of, or whether state of Georgia, state of Illinois. That's something for you to think about. And then when we get down here is something real curious, where it says the section of territory occupied by one of the United States. Now, this word United States is another word that we have to get some clarification on. Let's look at this word real quick. Okay, now, it is important for you to understand the three different senses that United States is used in. This is one of the reasons why a lot of the anti-sovereigns I'll say you don't understand law or anything like that, because they will never address
in what sense this term United States is being used in. So when you read something, they'll construe it in a certain kind of way. And usually this can be either attributed to their own ignorance or their deception. They're either trying to deceive you or they just don't know themselves. A lot of them are ignorant or very ignorant about the things we're talked about. And they just kind of subscribe to some sort of conspiracy theory or something like that. When, in my opinion, it's very easy to see when you read it. It's like, well, what are you talking about? It's not a conspiracy theory. This is evident, when you read the document of what they're talking about. But anyway, you'll see that the first sense of the word of United States is when it's used as a sovereign nation occupying the position of other sovereigns in the family of nations, like the United States, vice versa against France or, Spain or Germany or, England. It's the family of nations when they reference the United States, which is really the United States of America. The second sense is the one that we talk about mostly when we are referencing the United States as a corporation or the power that it exercises under Article 1, Section 8, Clause 17. They make references to the United States, the federal government, and the limited territory over which it exercises exclusive sovereign authority, or what they call legislative authority. Okay, what they own, and they usually label it, they let you know, they call it United States District Court, United States Post Office, United States Citizen. They usually label what they own, and they put it right in front of your face for you to see. When you see it starts with United States, they usually own it. There's a District Court of United States, and then there's a United States District Court. Two different courts. Go on Justia, and you can see what I'm talking about. But anyway, then you also have the third sense, which is United States, the collective name of all the states united by and under the Constitution for the United States of America. And those are the three senses that you'll see. The second sense is the one of primary interest. This is the one that, and a lot of the information that we are discussing about, the commercial nature of the system and so forth, that is the one that you're going to be paying a particular attention to. Okay, understand that the word United States has three separate meanings. It doesn't have one different meaning. It doesn't have just one meaning. And the anti-sovereign circles will make you believe that it does, and it doesn't. And that's why either they don't know out of ignorance or they're being deceptive.
Remember that proper names and proper nouns in the English language have only the first letter capitalized. For example, the federal state of Illinois is overlaid upon the sovereign state of Illinois. Further, it is designated by the federal abbreviation of IL in all capital, instead of the sovereign state abbreviation of capital I, lowercase l. So too is Arizona, designated capital A and capital Z, instead of the lawful abbreviation of capital A, lowercase r, lowercase I, and lowercase z. California, which is all caps, instead of Caliph, etc. If you are using a two-letter capitalized abbreviation, you are declaring that the location is under the jurisdiction of the federal government instead of the powers of the sovereign state. As a result of creating these shadow states, the federal government assumes that every area is a federal area and that the citizens therein are federal citizens. Okay, and I wanted to pause right here and bring your attention to a case, Jones versus Timmer. I actually had a listener who, made this available to me, which is a very good case. And it helps you kind of understand that there is a distinction with this federal citizenship. This is what we're talking about within this jurisdiction. And when you go down, you can read in the case, you can see right here, it says, the Privileges and Immunities Clause of the 14th Amendment protects very few rights because it neither incorporates any of the Bill of Rights nor protects all rights of individual citizens. And notice how they wrote the word citizens. See slaughterhouse cases. And it goes on, it says, instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. Accordingly, it is not necessary that plaintiff have non-resident status in order to bring a claim under the Privileges and Immunities Clause of the 14th Amendment. as discussed below in Section EA. However, plaintiffs have failed to state a claim under the Privileges and Immunities Clause of the 14th Amendment. So here you can see that there is a distinction between a state citizen and a federal citizen. That was my point in showing you this, that there are two types of citizenships, notwithstanding the fact there's plenty of case law to support that. I could just, right as you see right here, list all the different type of cases that show the distinction between state citizenship and this federal citizenship. You're being pulled into some sort of federal citizenship under the 14th Amendment that is under some sort of legislative authority. And you can see right here, even in this case, it talks about how you even get access to an Article 3 court, where it says right here, to overcome the Article 3 limitation on standing, often referred to as the injury in fact requirement, a plaintiff must at a minimum show an actual or threatened injury caused by the defendant, and that a favorable judicial decision is likely to redress the injury. There are, in addition, prudential principles applying to standing that limit the class of persons who may invoke a court's powers. In Valley Forge Christian College, the court listed the 3 prudential principles. Number 1, the plaintiff must assert his own rights and may not rely on the constitutional rights of third parties. Number 2, the court must not adjudicate generalized grievances that are more appropriately addressed by the executive or legislative branches of government. And number 3, the plaintiff must come within the zone of interest to be protected or regulated by the statute or constitutional guarantee in question. And right here, you can see this is where the separation of powers is. They will always defer to the executive and legislative branches of government. Okay, this is if you're trying to get into an Article 3 court, which is Article 3 branch is the judicial branch. You're not going into an Article 3 court. You're going into an Article 1 legislative tribunal that has been, they have the authority to create that under Article 1, Section 8, Clause 9. They try to give you the impression that they are still Article 3 courts because they put Article 3 judges in there and so forth. But separation of powers makes that a moot issue. This is why you have to understand the 7 principles of the Constitution. These people are so full of tricks. It is amazing. They don't lie. There's no law against lying. There's a law against committing perjury, which is why you can't get any of them to swear to something under penalty of perjury. A lot of these, anti-sovereign people, they make all these claims, but tell them, okay, well, get one of these public officials to sign an affidavit swearing to that we're lying and everything that we're, the things that we're saying are not true and the things that they're saying are true. Try to get them to sign an affidavit, see what happens. Title 4, United States Code Services, Section 110D. The term state includes any territory or possession of the United States. Title 4, United States Code Services, Section 110E. The term federal area means any lands or premises held or acquired by or for the use of the United States or any department, establishment, or agency of the United States. Any federal area or any part thereof which is located within the exterior boundaries of any state shall be deemed to be a federal area located within such state.
Notice, and he's going to expand on this a little bit later on, it can be a federal area even if the federal government doesn't own it. If, for example, a zip code, if the first digit of a zip code defines a certain area of the United States, that certain area of the United States is henceforth recognized as a federal area. No ownership involved, just an administrative declaration that for the purposes of distributing mail, this is a federal area whose designation is digit 1 or digit 5. So that all of the United States geographical area can become a federal area without the national government owning it. And in that way, they have covered the entire geographical United States with federal areas.
Okay, this particular paragraph was just chock full of words that you need to know the definition of. Okay, this is a very good example why it's important for you to look up every word. Once again, this is how the anti-sovereign circles are able to deceive you, because you don't look up the definition of words. And sometimes, as I said, they don't know themselves. They don't look up words. But one word I'm going to start out with is the word deem. This is a word, whenever you see it in any type of legal anything, especially in a contract, your antennas need to go up. Okay, the word deem establishes a legal fiction, and the definition of a legal fiction is an assumption that something is true, even though it may be untrue, but especially in judicial reasoning to alter how a legal rule operates. I still have it committed to memory. It was the very first word I ever looked up. The first time I ever opened a law dictionary, that was the first word I looked up was legal fiction, because I heard the word so much before I even started studying any of the material. That is a word you need to be acutely familiar with, because their entire system is based off of legal fictions. It's all legal fictions. It's fictions, okay? You got to understand that. So you need to know what a legal fiction is. Lon Fuller has a book that you need called Legal Fictions. It's like the authority on the subject. It is on SPC University website. You can click the link right there on the screen and it will take you over to SPC University, okay? But let's look at deem. This is deem, verb, to treat something as if, 1, it were really something else, or 2, it had qualities that it does not have. Although the document was not, in fact, signed until April 21st, it explicitly states that it must be deemed to have been signed on April 14th. Number 2, to consider, think, or judge. She deemed it necessary. And now we have some expert commentary that's going to shed some light and give you some deeper insights into the meaning of this word. Deem has been traditionally considered to be a useful word when it is necessary to establish a legal fiction, either positively by deeming something to be what it is not, or negatively by deeming something not to be what it is. All other uses of the word should be avoided. Phrases like, if he deems, as he deems necessary, or nothing in this act shall be deemed to, are objectionable as unnecessary deviations from common language. Thinks or considers are preferable in the first two examples and construed or interpreted in the third. Deeming creates an artificiality, and artificiality should not be resorted to if it can be avoided.
and that is G.C. Thornton, Legislative Drafting, Volume 99, 4th edition, 1996. And you can see what I'm saying. But yet, here we have an example of them using this word deem. Now, the next two words that we need to be familiar with are the words state and citizen. Okay, you got to know your nouns in this sense. You know, you got to know that a proper noun begins with a capital letter, and a common noun begins with a lowercase letter. There is no lowercase. This is very important when you're reading, because in law it is very scientific. I remember seeing a movie one time where there was a lady, she was a female, she was married to a man who was a doctor, and she told him, she said, my profession is just like, he was a surgeon, she said, my profession requires just as much precision as you do in surgery. And she's absolutely correct, because there isn't anything in their drafting, a single word that doesn't have any significance, all the way down to letter A, of, the, for, the prepositions, everything has a specific meaning, okay? And when you approach this subject, that should be in the back of your mind. When you're reading, you'll see like a lot of gurus and other people, they'll just kind of just not pay attention. They'll put the word citizen in a lowercase when it should be in an uppercase, and not really pay attention to the rules of English grammar. I'm not saying that I'm the best when it comes to English grammar, but it is something that I did freshen up on when I started studying this subject, because I understood that grammar is very, very important. So you need to understand the difference in these words state and citizen when they're referring to something in a proper noun context, and something when it's being referred to and so when something's being referred to as a common noun. Okay, that is very important, okay? You got to know, you know, usually when the word citizen, depending on the context of the citizen, it's referring to the republic. And the lowercase citizen is referring to the 14th Amendment citizen. When you look at the Constitution, prior to the 14th Amendment, everywhere you see the word citizen in the Constitution, it is capitalized. After the 14th Amendment, everywhere you see the word citizen, it's in lowercase. Okay, the same thing with this state situation. Usually when they're referring to the state, when they're referring to the republic, it's usually capitalized, and when it's not, it's usually in lowercase, depending on the context of the sentence. But you have to pay attention to that. I just want to draw your attention. You got to pay attention. What are they talking about? You know, they communicate very heavily using grammar. That's how it goes over so many people's heads, because so many people are not good at grammar. Grammar is something that you have to pay attention to. Another word that you have to pay attention to is this word land and the word lands. They're two distinct words. This is something that trips up a lot of people, even the anti-sovereigns and so forth. And you can see a land, which is a noun, is an immovable and indestructible three-dimensional area consisting of a portion of the Earth's surface, the space above and below the surface, and everything growing on or permanently affixed to it. Sense 2, an estate or interest in real property. And then we get some expert commentary on it. In its legal significance, land is not restricted to the Earth's surface, but extends below and above the surface. Nor is it confined to solids, but may encompass within its bounds such things as gases and liquids. A definition of land along the lines of a mass of physical matter occupying space also is not sufficient. For an owner of land may remove part or all of that physical matter as by digging up and carrying away the soil, but would nevertheless retain as part of his land the space that remains. Ultimately, as a juristic concept, land is simply an area of three-dimensional space, its position being identified by natural or imaginary points located by reference to the Earth's surface. Land is not fixed contents of that space, although, as we shall see, the owner of that space may well own those fixed contents. Land is immovable, as distinct from chattels, which are movable. It is also, in its legal significance, indestructible. The contents of the space may be physically severed, destroyed, or consumed, but the space itself, and so the land, remains immutable. Peter Butt, Land Law, page 9, 2nd edition, 1988. And then we have the definition of lands with its S. Lands, which is a noun plural, sense one, at common law, property less extensive than either tenements and hereditaments. Sense two, by statute in some states, land including tenements and hereditaments. Okay, and then when we look up tenements and hereditaments, okay, right here we get hereditament, any property that can be inherited, anything that passes by intestacy, which is to die without a will. You have testate and intestate. Testate means you had a will, intestate means you didn't have a will. So anything that passes by intestacy, which is very interesting because this will concept comes up a lot. It comes up a lot, which was very interesting when prepaid legal, which is now Legal Shield, you know, I thought it very interesting that one of the things that they gave everybody was a free will, which I thought was very important because, you know, probate is the biggest money maker for the legal profession because so many people do not plan their estates. And this intestacy thing was very interesting. So we have descent and distribution, and that's the Volume 8 Corpus Juris Secundii, descent and distribution, subsections 9 through 12, and right of privacy and publicity, subsection 42. And then we have the sense 2, real property, land, cases, property, Volume 4 Corpus Juris Secundii, property, subsections 14 through 21, page 23. So they have the hereditament and then tenement, a tenement, which is also property, especially land held by freehold, an estate or holding of land, dominant tenement, see dominant estate under estates under the fourth sense, servient tenement, see serving estate under the fourth sense. Sense 2, a house or other building used as a residence, and sense 3, an apartment, a tenement house. So right here we can see the tenement is almost like you're resident of something and you don't have the property. You haven't made any claims or anything like that. So this is what we're talking about, lands, the distinct difference. I want you to start paying attention to the differences in these words. You'll see these words in these statutes and things and people will assume they know the meaning of it. And there is a distinct difference between the word land and the word lands. Okay, they're two different words. Study them. I'll go in a little bit more on it in the future, but I want to just bring that to your attention when you're reading these things, how important it is for you to look up the words and stop assuming that you know the meaning of these words. There is no reasonable doubt that the federal state is imposing directly an excise tax under the provisions of Title IV, United States Code Services, Section 105, which states in pertinent part. Section 105, state and so forth. Taxation affecting federal areas, sales and use tax. Section A, no person shall be relieved from liability for payment of, collection of, or accounting for any sales or use tax levied by any state or by any duly constituted taxing authority therein, having jurisdiction to levy such tax on the ground that the sale or use with respect to which tax is levied occurred in whole or in part within a federal area, and such state or taxing authority shall have full jurisdiction and power to levy and collect any such tax in any federal area within such state to the same extent and with the same effect as though such area was not a federal area. Thus, the question comes up, what is a federal area? A federal area is any area designated by any agency, department, or establishment of the federal government. This includes the Social Security areas designated by the Social Security Administration, any public housing area that has federal funding, a home that has a federal bank loan, a road that has federal funding, and almost everything that the federal government touches through any type of aid. See Springfield versus Kennedy. The federal area attaches to anyone who has a Social Security number or any personal contact with the federal or state governments. Thus, the federal government has usurped sovereignty of the people and state sovereignty by creating these federal areas within the boundaries of the states under the authority of the federal Constitution. Article 4, Section 3, Clause 2, which states, Section 2, The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Therefore, the U.S. citizens of the District of Columbia, residing in one of the states of the Union, are classified as property and franchises of the federal government as an individual entity. Willing Steel Corporation versus Fox, Title 298, United States Reporter, page 193, and Title 80, Lawyer's Edition, page 1143, and Title 56, Supreme Court Reporter, page 773.
I'm just going to point out, for the sake of redundancy, that you and I are considered as property and franchises of the federal government. Welcome to the club.
Under the Buck Act, Title 4, United States Code Services, Section 105 through 110, the federal government has created a federal area within the boundaries of all the states. This area is similar to any territory that the federal government acquires through purchase or conquest, thereby imposing federal territorial law upon those in this federal area. Under federal territorial law, as evidenced by the executive branch's yellow fringe merchant law flag flying in schools, offices, and all courtrooms. So when you send mail using the two-letter capital abbreviation for the state, you are addressing the corporate shadow state created by the Buck Act as an extension of the Federal District of Columbia, and you are accepting the jurisdiction of the federal government within the borders of the sovereign states. Then, to really lock down their control, the federal government created an artificial person to whom they could address all their demands. This person is your name in all capital letters. Whenever you receive a letter from the government addressed in all capital letters, such as John Smith in all caps, instead of the proper English Christian appellation of the name, such as John Smith in upper and lowercase letters, they're addressing a legal fiction, a straw man, whom they assume they own. Since they are going on the assumption that they own this straw man, which they actually do not, and you can learn how you can take title to this straw man, they assume that whatever money comes into the property, or straw man, belongs to the master, which is the government in this case. What you are experiencing is an unprecedented grab for power by the federal government. In fact, agents of the federal government have no jurisdiction within the borders of these separate and sovereign United States or over the straw man, unless you give it to them. Hey, thanks for watching the video. If you like more videos like this, make sure you hit the subscribe button and hit the notification bell at the bottom of the screen so you can get more in-depth information only here, right on High Frequency Radio. Peace to the gods.
High Frequency Radio is the YouTube channel on which Yosef L. Publishes, and he's very smart. He does not his physical appearance in this shot gives you the impression that he's not as intelligent as he is.
You know, he's just cool.
Pardon me?
He's just cool.
Just cool? Okay.
Yeah.
See, I'm so older generation that I don't understand cool.
What is his name?
Yusef L. Y-U-S-E-F-L. I want to show you something. You've been given a large introduction as to the deceptions that have been worked upon the American citizenry. There is in Texas, there was created in Texas an educational program so that middle school kids and high school kids would learn about the structure and reasoning of government in the United States. It goes through exactly what you and I have learned in civics class in years gone by, and goes through the seven principles of government. It's very well laid out. I am quite certain that the teachers who designed this program of study were not aware that they were not living under this structure. Somebody upstream from this bureaucratic stream surely must be aware that we are living under Roman civic law rather than common law. But the students who are being encouraged to learn about civics and governmental structure, they still think that we are functioning under that structure, when in point of fact we are living under the Roman law as established in the District of Columbia. Because all of us in this room, anyone who has a social security number is a federal citizen. And they are no longer state citizens with a capital C. That's my next project, is to become a state citizen with a capital C. And I'll let you know how that goes. Thank you for your attention.